Hello and welcome to The Big Picture. The debate over what constitutes sedition, an act against the state as described under Section 124A of the Indian Penal Code, has been revived. The issue has again cropped up following a circular issued by the Maharashtra government last week with guidelines to the police detailing when and in what circumstances they can evoke the sedition charge. This comes 5 months after the Bombay High Court had rejected the charges of sedition against a cartoonist, Asim Trivedi, who had been charged with it in 2011 for having drawn cartoons parodying political class and national symbols. The Maharashtra government circular is being seen as violative of the freedom of speech as well as dangerous, as any criticism of a politician or elected representative can be construed as sedition. While this particular case and the government circular needs a discussion, the larger issue of whether the colonial concept of sedition should still be in the statute books also needs to be discussed. We will discuss this today with Soli Sorabjee, an eminent jurist and former Attorney General of India, Marwah, former Governor and also former Delhi Police Commissioner, N.D.Pancholi, human rights activist, Sanjay Hegde, advocate in the Supreme Court, and on the phone line from Mumbai is BJP spokesperson Shaina NC. Welcome to all of you. Shaina, I want to come to you first and why was this, what is this confusion about this circular, and your government is saying that this has been done according to the High Court guidelines. Shaina, can you hear me? I think there's a problem there. Mr. Sorabjee, how would you look at this circular? You think that the High Court is supposed to have told the Maharashtra government to issue this circular, but there seems to be a problem with it.
The main thing is, let's be very clear. The section has been construed by our Supreme Court in the famous Kedarnath case. And the Supreme Court ruled that only acts or speech which have a tendency to incite violence can come within the mischief of the section.
Okay.
And that is also government established by law. Now, so however strong criticism, however vigorous the comments, that doesn't amount to sedition, that's the law. Now, if the circular by any chance tries to go beyond that, I think it's contrary to the Supreme Court judgment. I think there has been some mix-up, because I believe there are some people like President of Zilla Parishad, Mayor, now they are not government established by law in any case. And please remember, libel or defamatory statements made about those people is not sedition. Essence of sedition is incitement to violence.
Incitement to violence. You say that incitement to violence is the key to the whole thing. But again, Mr. Sorabjee, the
yes,
fear,
of course.
The fear is that as long as this section exists in the IPC, what constitutes that kind of a fear can also be misused and abused, and which we have seen happening in the case of this boy Asim Trivedi, drawing cartoons, invoke charges of sedition against him.
Yes, that's an absurd thing, but anything can be misused. The very possibility of misuse doesn't mean that you repeat the section. You apply the section as construed by the Supreme Court.
Okay. I think we now have Shaina, the spokesperson of the BJP, on the phone line. Shaina,
yes.
Shaina, is the problem in the translation, or is it the problem of the government not being able to understand what the High Court had said, and coming out with a circular which seems to have caused quite a lot of problems?
I think you need to understand few points. First, this is not a government resolution. This is a circular. And this circular is only a directive of the High Court. The Honorable High Court said that there has to be a translation of this, and the circular must be given to all police stations and police personnel. Now, the point is, the contradiction that people seem to have is that to suggest that the BJP government has done this. If at all this affidavit was filed by the previous government, the BJP has only acted on the directive given by the High Court. And please believe me when I say we are open to all criticism, but criticism does not amount to sedition. The fact that we have government officials and public servants as in elected representatives under the same ambit is clarity to the point that there is no contradiction in term, and under the Supreme Court guidelines of sure that he is accountable. If you are going to have people take on anti-India campaigns, hate campaigns, surely there will be.
No, that
Nobody
is fine.
against any
But
kind
one
of
second.
criticism. We are an accountable, sensible government.
1 second. The Marathi translation apparently says the charges should be invoked only if words, signs, or representations show politicians or public servants as representatives of the government. What does this mean? And this is so vague that that police can easily misuse it.
Sir, if I can just repeat and at the cost of repetition, may I please highlight exactly what we have said. The fact that the Supreme Court talks about government officials and elected representatives is both for the same reason, which is that public servants means all government officials and elected representatives. If you want to cover elected representatives in the Anti-Corruption Act as per Supreme Court, then we have to make sure that everyone falls under the gambit of public servant. And the criticism of public servant does not amount to sedition.
What? Then why is it included here? Sanjay Hegde, would you like to respond?
I don't get what Shaina is saying, because essentially the crime of sedition is against something impersonal. It is against the state.
Exactly.
It is not against individuals. Right. It is not to protect individual honor, individual dignity. In a democracy, you are free to call all your elected representatives a bunch of fools. That will not be sedition. It may be defamatory. For that, there are other remedies.
Right.
But sedition is violent speech which is aimed at overthrowing the state. That is what the Supreme Court has said in Kedarnath.
Yes.
Now, just because an opportunity presented itself when the Bombay High Court asked for them to issue a circular, they seem to have issued a circular including everything and all kinds of speech against elected representatives. Sorry, elected representatives are not the state.
Not only the elected representatives, public servants as representatives of the government.
Absolutely.
Now that is again...
So an IAS officer.
Exactly.
If you say that such and such an IAS officer or such and such an IPS officer is not worth his office, would that be sedition?
Who is a public servant as representative of the government?
Absolutely.
So this kind of description is what has created the problem.
It is overbroad. And a circular has gone far beyond the words of the statute. Sedition has to be used very sparingly, and because it was abused in the Asim Trivedi case, the High Court asked the Advocate General to put in guidelines in the form of a circular. They took the High Court order, but in translation they translated it so broadly that it will not stand the test of courts.
Okay, Mr. Pancholi, this whole concept of sedition itself.
You see, this is a provision which was framed by the British,
exactly,
in order to curb this our movements, this revolutionary movements, the opposition to the British government, and it was imposed against Bal Gangadhar Tilak, Gandhiji, M.N. Roy, many of our leaders. And at that time, during several resolutions of the Congress party, the resolutions were that when we will become free, we will remove this. but still they are continuing, and the demands by the human rights organizations, it is our experience. It is always misused. Most of the cases, it is always misused. I myself was arrested in Sedition in 1984-5 because we criticized at that time the operation going on in Punjab. The Blue Star operation, we produced a report, 200 pages report, and it was immediately banned, and we were arrested. And when we were produced before the court, the magistrate asked, why you have arrested them? The policeman, the IO said, sir, they have written a very seditious book. Then he said, where is the book? Sir, I have not brought the book. He said, no, I will not send them to custody. You bring the book. Then in the evening, he brought the book, and then magistrate asked, what they have written, you show me. Then he said, sir, I have not read the book. You have not read the book, and you have arrested them? And then arguments for several days, and the magistrate said, no, I am not going to send them to, unless you satisfy, and we were freed. So there is always misuse. And on behalf of UCL, I am founder member of POCL in 76 emergency, and we are continuously campaigning against its abolition.
Yeah. Mr. Marwah, it is your class which is which is on
No, it's
which
not
is
my,
on test.
It is not my class
The
which
police
has done it.
class.
No, it's
I'll come to you, Shaina, 1 second. Mr. Marwah will.
There may be one or two cases, odd case where such a thing has happened. And as Mr. Sorabjee has very rightly said, every law can be misused. The remedy lies not in eliminating the law from the statute book. The remedy lies in taking action against the person who misuses the law. And for that, you not only have the hierarchy of the whole police department and the government, you also have the courts to intervene. And I think there are enough checks and balances in our system where a wholesale exploitation of sedition law cannot be done. And I think in the present situation, the way violence is threatening the very unity and integrity of our country, this law must be retained on the statute.
You think it should be retained?
It should be retained.
Mr. Sorabjee, would you agree with Mr. Marwah that this law needs to be retained?
Retained in the sense it has been interpreted by the Supreme Court. The law has to be confined to speech or activities which lead to incitement to violence. That's the main thing. Libel is not violence, not sedition. Defamatory statements is not sedition. And what I don't understand is there's an offense against the government established by law, as Sanjay Hegde said, against the state. How are these people coming in? Presidents of Zilla Parishad, mayor and others. Surely, if you make defamatory statements against them, they can have recourse to the remedy similar criminal law of defamation. But that's not sedition. I think it's gone a little overbroad, and I think there's a legal confusion in not distinguishing between acts which can amount to sedition according to law, as interpreted by the Supreme Court. Absent incitement to violence, there is no sedition.
Okay. Shaina, you think that would you admit that there is a mistake there? Because as Mr. Sorabjee, Mr. Hegde, points out that how do you bring in individuals into this? Sedition is an act against the state. It can't be against individuals.
I do concede that sedition is an act against the state, but for all those anti-nationals and all those people who choose to repeatedly be hate mongers, this is a circular, not a government
hate mongers
resolution.
against whom?
The High Court has
No,
issued
hate
these
mongers
guidelines.
against whom?
Obviously against the country. And please, when we talk about a circular, it does not amount to a government resolution. A High Court has issued that these guidelines should be adhered to and asked the government to give it to all police stations.
How
this
is
is
it
a verbatim translation from Marathi to English, and the order has been issued by the High Court. It's not been issued by the government.
Sanjay Hegde, does High Court issues this kind of
The
orders?
High Court order prescribed something.
Yes.
But while prescribing,
but now they are saying that the High Court has issued it.
No, the High Court had asked them to produce guidelines. The High Court had suggested broad parameters on which the guidelines could be drawn. But using those parameters, they have stretched it so hard that it has covered everything. I'll just tell Shaina an instance from Maharashtra history. There was a Peshwa called Narayan Rao, whom his uncle said, Dhara, hold, bring it. Somebody changed that to Mara, and he was killed. So this kind of behavior, where you take an order and then you extend it, is not unknown to the state of Maharashtra.
But my question is this: when Shaina says that the High Court has issued this directive,
The High Court has not issued that directive. That is clear from the High Court order itself. And in translation,
High Court wanted the state government to bring out a circular
so that
with
sedition law
guidelines, with guidelines.
so that
And
sedition
these
law
are-
was not misused in
So
this
it
manner.
is the government's guideline. It is not the High Court's guidelines.
No. These are guidelines issued in pursuance of the High Court order. So in implementation, they have gone way beyond.
Is this normal that in every High Court? Yeah, Shaina, you want to come in?
Yes, please, if you allow me.
Yeah, please. I'll come to you, sir.
Let Shaina come in.
Yeah, Shaina, yes.
Yeah, let her come in.
Yeah, this is in no way interpretation of the government. This is a verbatim translation from Marathi to English, as I said earlier, by the High Court, and this order has been issued by the High Court. Various interpretations are based on half reading and obviously not understanding of the legal language. And having said that, the public servant that they are referring to includes all government officials and elected representatives, because to cover everyone under the ambit of Anti-Corruption Act, as the Supreme Court has said, they have included everyone as a
Supreme Court
public
said
servant.
anything.
Anti-corruption, nothing to do with
Criticism does
sedition.
not amount to sedition, and please, finally, this affidavit of government was filed by the previous government, not by us. We are only adhering to the High Court guidelines.
Mr. Sorabjee? No, where does I am also confused. Where does the Anti-Corruption Act come in?
No. Not at all. We are not concerned with public servants and the Anti-Corruption Act. We are concerned with a very serious offense of sedition.
Right.
The basic point which is not met is it's an offense against the state.
And
As the section says, elected government of the day. So how do you bring any statements against those people who are mentioned, the mayor, president, Zera Parishad, in the ambit of sedition? They may have other remedies. If they are defamed, they can have the remedies like civil remedy of damages, criminal remedy of defamation. I think government has rather misconstrued what was required
no,
to be
because
done
she
of
is
them.
talking about a
And as
Supreme
Shaina
Court.
says, it's not an order.
There is no Supreme Court order.
Is there a Supreme Court order?
No, Supreme Court, best thing is,
There's a judgment of 1965.
Supreme Court didn't do guidelines on these lines. Supreme Court expected them to have the guidelines in keeping with the law laid down by the Supreme Court.
Absolutely. Mr. Marwah.
I mean, the High Court did not.
Okay. Mr. Marwah, you think that, including these public servants, which will include police, and which may include police officers, which may include many other government servants, is the right thing?
No,
That
no,
do they require that kind of protection?
No, I entirely endorse Mr. Sorabjee's views that sedition is against the state. It is not against individual
No,
officers.
for instance, Shaina was saying that there are hate mongers all over the place, and you need this kind of a law.
No, there are other laws to deal with that. Sedition, as he very rightly points out, is a very serious offence, and it cannot be used as an omnibus law to prosecute each and everyone. And here, I think, if clarification of that circular is necessary or a revision is necessary, that should be done.
Is there, Mr. Hegde, now, can Supreme Court step in at this point of time, or is it within the jurisdiction of the High Court to clarify this?
Well,
Because, you understand, as Mr. Pancholi was pointing out, there is this huge scope for misuse of this kind of orders.
absolutely. You see, the government itself can resolve it. If the government does not resolve it, somebody can always take it back to the High Court and say, this is your judgment. And pursuant to that judgment, the circular was issued. This circular is not in terms of your judgment. They can take it either in a fresh petition or even in contempt proceedings. I see no reason why it can't go back to the High Court. But why do you want it to go back to the High Court? If you have made a mistake,
This is something
which is so basic,
and
it is so
within
basic.
and within the jurisdiction of the government to do it.
Absolutely, the
Because-
government can issue
because
a
one of the-
circular and it can withdraw.
No,
a circular.
because one of the officers have been quoted, one of the senior officers of the Maharashtra government has been quoted saying that if we try to change it, we'll be committing contempt of court.
Absolutely not. If you implement a High Court judgment and you make a mistake in implementing it, you can always correct yourself. That will definitely not be contempt.
So the deputy chief secretary, additional chief secretary of Maharashtra government says that we have done only according to the government the
You
court
see,
order.
any government, I'm not speaking of this government. Once a government takes a position, it takes a long time in withdrawing from that position. And unless there is the threat of either public anger or a court order, they don't go back.
Shaina? I think we lost her. Mr. Pancholi?
You see...
No, but the larger issue also needs to be discussed here.
Yes, yes, larger
but,
issue...
No, but Mr. Marwah and Mr. Sorabjee also thinks that because there's a Supreme Court, framework, it has to be under that.
You see, so that's...
What is wrong with the Supreme Court's framework? Which is
No, Supreme Court, there is nothing wrong.
perfectly
There was, in my opinion, there was no necessity for the High Court to ask the government to issue any guidelines because...
Is this done as far as every High Court or every state is concerned?
See, there are lots of matters where the High Court knows that you can't legislate or plan for the future. Therefore, they say, this is the law. We know that you, Mr. Advocate General, know the law. Please instruct your officers how to handle the law. And for their guidance, get the government to issue a circular. It happens in various cases. It's not only in
but in my opinion, it was not, because there are series of judgment and that Kedarnath judgment of 1965, that is absolutely clear, and there is nothing to be
tinkered with.
Yes. It is an offense against the state. It is so serious, you can't leave it to the hand of the policeman. You see, sedition, even if a policeman files a charge sheet, it has to do at the instructions of the government, and you cannot prosecute the case unless you get a sanction from the from the state. So it is within the power of the state. State has to decide, not the policeman. Now they are giving power which they should have to the policeman.
Mr. Marwah?
I think Mr. Pancholi knows very well that police investigates, registers the case and investigates case.
And does it have to get the permission of the state?
After that it goes to the prosecution branch, and prosecution branch scrutinizes it from the legal point of view and makes a final say whether the case should be sent in charge sheet or not. And here again, additional checks can be made to say that the public prosecutor or somebody higher enough in that hierarchy scrutinizes the case. I think there's nothing wrong with that.
No, but sanction, it cannot be prosecuted. The case cannot go to the court unless there is a sanction by the Criminal Procedure Code, Section 195, 94 or 95, Criminal Procedure, they have to get sanctioned. Otherwise, it cannot go. Government has to give sanction.
And you say that in the case of Maharashtra now, this whole sanction has been overlooked?
No, they can't do. 124A, they have to get sanctions. This is a legal provision.
You see,
what is sanction?
Without sanction, a magistrate cannot take cognizance.
Okay.
Yes.
So but often sanction is again in the hands of the government. Now, if the government is determined to put somebody in under sedition, then it can very well do so. Now, the basic point is this. Sedition is punishable.
There is no checks and balance there.
There's one great disproportion. Sedition is punishable by life.
Exactly.
Whereas defamation is punishable with a maximum of 2 years.
Right.
Now, there is obviously a greater sword in the hands of the government when it wants to silence someone if it invokes sedition.
Right.
And that is where the propensity for misuse comes in.
Shaina, all the panelists here, including Mr. Sorabjee, Mr. Hegde, they're all agreed that there seems to have been a mistake. And is your government ready to rectify this mistake? Are you first ready to accept that there is a mistake, and second, that to rectify it?
I don't think there's a mistake, but at the same time, I respect all your panelists and can only assure there will be no misuse of law. We lead by example, and especially our Chief Minister, Mr. Devendra Fadnavis, has proven time and again. Just to narrate one single incident, if you recall the last incident where there was this person in Nagpur that has used the most obnoxious, perverted language on social media vis-a-vis
Against
the
whom?
Chief Minister, etc.
Against whom?
It was not. These are not single incidents.
No,
You
against
have
whom was
incidents
it
such
used?
as this
Shaina, against whom was it used?
against the government, against the chief minister, etc. But this is not
Chief Minister.
even
The Chief Minister is not
on
the
a single
state.
incident. These were repeated incidents. Then you have all these campaigns which are anti-India, pro-Pakistan. Why shouldn't we also have a provision to ensure that if there are people who are not patriotic in spirit and not nationalistic in emotion, they must be dealt with severely too.
Oh.
So I think that one needs to see the flip side as well. And here we are not suggesting for a minute
No,
that
you
there
are
will
saying
be any
you-
misuse.
saying
And at the same
nationalistic
time,
in
it
emotion.
is-
That's a very
Slippery
slippery slope which one can take. And this is exactly the fear which people seem to be expressing. Mr. Sorabjee, would you like to react to that?
No, she's right. Hate mongers and others should be dealt with, but not by invoking the provision of sedition. Have another law to punish them. Of course, we don't want hate mongers. We don't want people who all the time shout anti-India slogans. But that's not sedition. Please don't confuse the two.
There seems to be that confusion. Hegde, very quickly.
Well, just to give you an example, I'd written about it. There were students of Kashmiri origin in Meerut who were prosecuted under sedition.
Exactly.
For cheering Pakistan
For cheering Pakistan's cricket
during a cricket team. A cricket team is not a nation.
Cricket.
That's point one.
Cricket.
Point two, saying that I prefer this team or that team is not sedition. It becomes sedition only if you say Kashmir banega Pakistan and that we will take it by force of arms. That is what the Supreme Court said. That
Right.
when you incite violence, that is when it becomes seditious.
So, Shaina, you still don't want to agree that there has been a mistake.
There is a difference between criticism, which is amply welcome, and sedition, which we all agree on. I don't think our government is interested.
I don't- okay.
On the scene cases,
Okay.
committed to ensuring that there is no compromise with national pride and patriotism.
Okay. I think it's very clear what the Maharashtra government is thinking. As some of my panelists feel that there seems to be a mistake, but they don't seem to be admitting that there is a mistake. Anyway, we'll have to wait and watch how this will all go about. Thanks to all my guests. Please keep watching. We'll come back with another issue in the big picture same time tomorrow.